Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for November 3rd of 2025. Brad, go ahead.
I hate to start on one being so critical of an attorney, but
Thank you. Thank you. Because that I was going to say the same thing.
I,
Thank you.
but there's at this point there's just no way around it. So let's start. So we're in Georgia, where we have families who have sued the county over a fire station's failure to respond to a house fire. Now, let me tell the facts as we believe we know them. Right, and this is just a lawsuit, but a lot of criticism I'm sure we're going to have to offer here, as Curt and I do. But the facts are that there was a disabled family who, I guess, allegedly made arrangements with the firehouse right across the street saying, listen, we're going to have mobilization issues if there's ever a fire. And in fact, then there turns out there was a fire and the fire station didn't respond. The reason we believe that they didn't respond is because they weren't alerted. And that there was actually a malfunction with their alerting, and they were right across the street apparently from the fire. So they slept through it, but not in the way that it's couched in the complaint. They were never alerted. It was kind of disingenuous, but nonetheless. But the problems are of a technical nature. Oh, and then the individuals died, right? And which is important for this. So those are the facts. But the lawsuit is so plagued with problems. I want to start with one. You go through some of them, but I want to, well, the ones you go through is they serve the wrong people, right? They sue the county, they sued the state, I think,
Yep, the
right?
state.
Um,
And they sued the fire station. What the heck?
right, which is not
What is the
anything.
fire station?
Right. And I actually
It's
had to
not a
check.
legal entity.
Right. And this is actually an attorney who's doing this.
Yeah.
But then you piqued my interest with all your criticisms. I'm like, well, maybe there's more. There's a 2-year statute of limitations,
Hmm.
and they missed it. This occurred on October 14th of 23. They filed this October 20th.
Oh
They
boy.
missed it by 6 days. So it's probably getting thrown out right off the bat for that.
Is it a 2-year statute for negligence in
Yep.
Georgia?
2-year
Oh
statute,
wow.
section 9333.
Wow.
I looked it up.
Wow.
And then it gets worse. There are more issues. The claims against counties, because there's something called, for the viewers, a notice of claim, right? Or a notice of intent to sue. And that basically says, listen, a state and a county, a municipality will waive its immunity from a lawsuit, but only if you meet certain requirements. One of those requirements, you're going to like this next one. One of those requirements is that they have to present a notice of claim. Now, I didn't see it in the statute that they ever said they did, or I'm sorry, in the
In the
complaint, I
complaint.
didn't
Yeah,
notice that they
they
said
did.
they did say it.
They filed a $30 million claim, but I'm not sure who they filed it with.
Well, but look at the date of that. So the notice of claim has to be filed within 12 months so it has to be filed by October 14th of 24 against both the state and the county. There's two separate statutes that do that. So, but to me,
Well,
this 2-year
this
statute.
is a consolidated municipal entity. There is no county anymore. There is no city anymore. There is this third entity, which is a combined entity, and I'm sure it's the state legislature created this entity.
Yeah.
And
Yeah.
when I first started practicing, anything I did, I had to show my dad before it got submitted.
Me too. Me
And
too.
there were three other attorneys in the office, and very often my dad was busy. I would talk to one of the other attorneys, and I get a little bit of guidance and how to do it, how to sue a municipality, what you got to do, what hoops you got to jump through,
Yep.
how to sue a corporation, all those things they don't they don't teach you in law school. But in fact, the secretaries were instrumental
Oh, yeah. Yeah. Yeah.
in
No question.
helping know what to file and where to file all the stuff they don't teach you in law school. Okay, but you've got to sue the right entity. You can't, if somebody gets hurt in Walmart and maybe in the pharmacy at Walmart and you sue Walgreens, you got the wrong defendant.
So here's the funny thing. There's no question, right? there's no question this happens. Let me confirm the dates because I'm looking at this. This is kind of funny. So the facts, they say October 14th, 2023, right? The filing date, start with this, is October 20th. So they missed it by 6 days. But then the notice of claim, right? So they refer to it by a different name. Maybe that's
Right.
what they call it, an anti-litem notice on
Mhm.
October 11th. So they get it right in
Well,
time, 3 days before the 14th.
well, a lot of time, like most places I'm aware of, you got to file that claim within 60 or 90 days.
Right. And that's why I was looking. They
You don't
apparently
have two
get a
years to
year.
file a claim.
Yeah. They apparently get a year to do it as against a county or a state, but
Okay.
there is no, right. I
Yeah.
mean, they sued, it seems like they sued the
I,
wrong party in any event, but
and unfortunately, the only person I think that even as a stretch that they sued properly would be unfortunately the chief. But
yeah.
they said he's the chief of a non-existent
Entity.
entity.
And beyond all of that, come on, they clearly know years later there was a malfunction,
Right.
right? In the and it, they're there. It certainly wasn't intentional. It wasn't reckless. They thought they were going to get alerted. They didn't. I,
Right. Those
it's
guys, I mean, those guys and gals, they must have been really upset. I can imagine. I mean, I
oh,
never liked missing a fire to begin with because you're out of service for stupid
right.
things, mechanical or training or whatever it was, you know. But to have another company get in across the street from you and then it's a fatal fire, those folks have got to be beat up. And to have a lawsuit filed, making those kind of allegations against them without any sort of, you have a requirement that of due diligence requirement that we research and only plead things that are true.
Right.
Good
And
Lord.
it looks like the attorney doesn't even know because they pled negligent hiring, training, and supervision. To what? It was a failed alerting system. It sounds like they don't even know what it is that caused it. So
Yeah. Oh, God forbid they were asleep because they work 56, sometimes 72 hours a week, and they don't get overtime unless they go over the maximum. So yeah,
yeah,
that's one of the reasons why firefighters are allowed to sleep.
this is getting dismissed in days, and you know what?
Well,
I,
there's another thing, and I didn't want to go on and on and on about this,
I
but he filed an amendment, or the attorney, I'm not even sure, male, female, and you know what, it doesn't matter. I hope if the attorney's listening, you're not taking it personally, but geez, we've got to like let our listeners, readers and folks know. Um, the the attorney filed an amended complaint, which usually you're allowed to file one amended complaint without any sort of court approval. What we're looking at is the amended complaint. I couldn't find the original. The originals are not available on
Oh
Lexis.
wait, so is there an original complaint?
There must be an original complaint. This is Brad. This is the amended complaint. He had the opportunity to fix it. So, you're talking about the dates.
Then I'm
Yeah.
talking
You know
about
what? Let
statute of
me. All right.
limitations.
Well, if you wanna talk, I can go back because
No, we don't have to get that into it.
no, well,
It's
I
just
found the case. No,
possible,
I
right?
think that's an important point. I found the case on Lexis, and but unfortunately, it did not have the documents. At least sometimes it takes a while for the stuff to get uploaded. So,
Yeah.
if you wanna
No,
talk a
I
little
don't
bit.
think. Look, it's possible they missed it. It's possible they did. I'm
Yeah,
presuming they didn't. I didn't even realize this was the amended complaint.
yeah,
And then there's questions whether they amended it in time. Whether they need permission because they're now amending it after the statute of limitations. My bet is they probably filed it weeks before that, and they're within some period where they have
yeah. I've
the
I've
ability
got it
to
right
amend it
here.
as of
I've
right.
got it right here, Brad. The original. I'm sorry. The original complaint was filed on October 13th.
There you go. One day before.
One day before. So they didn't miss the statute of limitations. Um, and then the amended complaint was filed on the 20th. Okay, yeah.
Okay. So, and that
So,
probably was as of right. If you
but
file a document, you have so
yeah,
many
but
days to amend.
another thing, there's no they sued, they named the state of Georgia, but there's no factual allegations to
Right.
allege that the state of Georgia did anything constituting negligence or recklessness or willful and wanton misconduct.
Yeah, this is so problematic for so many
You know.
reasons, but
And hopefully it was a young attorney that, maybe first time out that didn't, I was really fortunate. I went to my dad's practice, you did. So, we had a little bit of,
guidance.
senior
Yep.
man, guidance.
Yep.
It's like
Yep.
sending somebody to the roof and they've never, right out of the academy. Go get it. Go
Yeah.
get the roof, kid. But,
Well, like us,
so,
you'd probably fall right through. So, yeah. No, anyway, and look, I mean, we would probably have a different tact if we felt this lawsuit had merit, but it's
yeah,
insulting. It's
it is.
unfortunate it happened, but it's insulting.
It is. It is. Both you and I have two lives. We got the fire life and the law life, and one is offending, really, truly offending, the other. And that's, I think, one of the reasons why we're saying what we're saying. We're being so critical of the attorney. But
Yeah. Well, and maybe it's not the attorney's fault. Client walks in, but I've told a lot of people. I tell people every week, I'm sorry, I'm not going to take that case. So,
I
as
say
you
that
do probably too.
more often than not.
Yep.
Yeah, unfortunately.
All
So
right. Well, I think we've given that enough time.
yeah,
We're going to go to Santa Barbara County, California,
yeah.
where we have a federal court which has dismissed a lawsuit. Today is actually lawsuit day. I think everything's a lawsuit we did today, and one burning question. But so the court dismissed a number of claims in a wrongful death lawsuit, which arose from the death of a Santa Barbara County jail inmate who was injured in a traffic crash and later died from a pulmonary embolism.
Mhm.
You provide this case more for learning, right, and policy, and we have some policies and the must-have policies that start to address this about how we act with the police. So the short facts are there was an accident involving the police officer or the sheriff's deputy. There's injuries to the inmate, and instead of waiting for the paramedics, the sheriff put him in his car or vehicle and got him to the hospital.
Yeah, I think there's one of the factual questions that got me was according to the complaint, the sheriff's deputy prevented the medics from treating or transporting the patient. And I think that's different than not waiting. That's saying, no, we got this and stopping us from doing that. And I think that I'm surprised the fire department wasn't sued. I'm glad the fire department wasn't sued, but
Right.
certainly, in a different circumstance, different attorneys, you might have seen the fire department sued.
Right. So here the sheriff wins, right? They
Mhm.
win because and it kind of makes sense. They had to show deliberate indifference,
Mhm.
and the court says, "Come on, he drove him to the hospital, right? Whether he should have or shouldn't have, drive it, he did. So there's no deliberate indifference. And as far as any constitutional right to medical care, he did that. He got him to the hospital. And they said, there's no real what we call Monell claim. There's no violation of the city to have a policy written or unwritten that allowed poor training of this individual. They said no, it's too. There's not enough facts to support this. Too conclusory. In any event, but the court did say we'll allow you to amend the claim to show that you don't train your people. And I got to tell you, I'm guessing there's probably no training of by I'm not sure who would do it, the county, I presume, but I'm guessing there's no county training that says to sheriffs, listen, if you're in an accident, drive the person to the hospital yourself, don't wait. So they're not going to show that there's a policy
I would
of
think the policy probably says the opposite. The policy probably says if the patient or the inmate is injured, get them medical attention,
and
not
you
wave it
know
off.
I was thinking that would be too, except wouldn't they have included that and then said you violated your own policy, non-discretionary, you lose. There they would have, right, could get rid of some immunity. I mean, that would have been
Well,
good, but wasn't
I
here.
think one of the things, Tim, we've said this, it will sound like a broken record, but this is not a negligence claim. This is a civil rights claim. And the reason why attorneys in a fact pattern like this would sue under civil rights is they don't want to have to deal with statutory immunity, sovereign immunity issues that arise when you sue government for tort. So they very often, when it comes to police officers, excuse me, I don't know. So,
As if the
they're
fire
looking for.
department gets alerted to hopefully
Yeah,
not
yeah. I'm
somebody's
sorry. I
violation of their
apologize.
constitutional
It's
rights.
just the notification that just came out. Uh, but where 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 were we? Now my dog's barking.
So the reason people sue for constitutional violations as opposed to negligence violations, you said,
Right.
is that they don't want to deal with sovereign immunity.
Right. Yeah.
Uh,
So they go, and very often we see this in law enforcement where they'll go after the civil rights aspects of either an arrest or an apprehension, a pursuit, or how they deal with someone who's already in custody. And so that's the route. So we look at the facts a little bit differently. You've got to show that level of deliberate indifference and the fact that he drove him to the hospital. But I think the lesson for me when I was working on this and writing it up was really we've got to up our game when we're dealing with the police. The police are a target. Okay, they're a target of anger in society, I guess you could say, but they're also a target of many lawsuits. And we're finding ourselves dragged into these things more and more. And we've got to understand what we've got to do, not to change the way we do things. We need to be doing things right, but we got to be documenting that we're doing things right. So
well, and I could see where somebody just puts no patient found, and that's the report,
yeah,
right? And that's not helpful to anybody. You should
especially when
document everything.
especially when you are on the police body cam standing there.
Yeah, yeah. So document it all.
Yes.
And listen, if you're one of those people who thinks you're not going to get sued in your career or part of something that ends up in court,
Mm.
even if you're not the target, you're probably right. You're probably right because with the number of people there are, the lawsuits are minimal. But if you're wrong, is it worth it? Is it? It's never worth it. And you said on the last show, and correctly so, being part of a lawsuit or being a witness or being investigated is so stressful, which it is. And you just don't want to put yourself there. Document everything because
It's easy to trivialize what people go through when they're involved in this, but many people end up in counseling. They end up on medication
right.
to deal with the stress and anxiety and depression that kind of accompanies this.
Yeah, and
Uh,
one of the things you said in your blog, it almost takes me back. I know this is not going to seem relevant first, but to a George Floyd video. One of the things you said in your blog is that we should be advocating for the patient. I'm changing your words, but we should be there saying, no, 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 we'll take them. We'll take the patient. Don't take the patient to the cop and arguing with the cop almost, listen, we'll take care of them. Let us do it. Look, the cop may be injured in this case, not thinking right, maybe nervous, may have a head injury, not making good decisions, right? But generally speaking, when the police are saying we're taking somebody, unless it's a violence issue or whatever, if you need to provide care, provide care. And it got me thinking of the George Floyd thing where two of the paramedics we just stood there. We shouldn't have stood there. We should have got involved sooner. And they're all kicking themselves. And look, they didn't look too good either. So that's, take a lesson and show that you're advocating for the patient. You're not supporting the cop. You just need to support your own job.
Yeah, absolutely. And I think there's some tactical level things that firefighters have to think about. There's also some strategic level things that are beyond what a firefighter can do. They're really chief issues. The fire chief and the police chief,
Need to get together in advance
yeah.
as you're being
Uh,
alerted. We all get it. I'll finish your sentence. The fire chief and the police chief need to get together in advance, draft a policy and be
and work through
clear.
these issues because at the tactical level, they're not going to be able to work those things out. You're not, if you've got a police officer that is in
Right.
the process of apprehending somebody, that's not the time to try to work out what your role is. It's too
Exactly.
late. That needs to be worked out ahead of time. Both sets of chain of command need to be issued rules and trained on it so that everybody knows if the person is having trouble breathing or whatever it is, the medics are going to take over, assuming that the person is behaving
Right.
appropriately,
Right.
okay,
Right.
and so on. So,
Good. All right. And by the way, you and I had said that probably 2.5 years ago because we ended up writing a must-have policy on it.
yeah,
And for everybody who knows, Curt and I run a policy service, which is growing every day. And if you want to look at it, go to musthavepolicies.com. But we follow up on every issue that comes from a case. We're like, wow, there could be a policy on that. No one else is doing that. There's not another service out there reviewing every fire service case and say, what can we learn and how do we prevent it from us? And that's what we're doing. You're doing it. Okay. So now, despite, starting with one not good lawsuit and one lawsuit that got dismissed, here's the first of 3 lawsuits where this has got some merit. I mean, I'm curious what you think, but I think this has merit. Back in California, we have a motorcyclist, and having been a motorcyclist for many years, I understand this. The motorcyclist filed suit against several public entities alleging that a fire truck damaged a water line, created roadway conditions that led to a serious crash. And the plaintiff was riding his motorcycle, right? It's funny. I had to keep looking like, California? Are we in California?
In San Bernardino too. I mean, a lot of desert, a lot of.
Yeah, well, right. The motorcyclist came across a pool of frozen black ice and lost control. Okay, well, there's ice in California. I know there is up top, certainly, with mountains.
Yeah,
That's what happened. There, yeah. But hours before the crash, a fire truck that was operated by San Bernardino County Fire, allegedly, right, struck a water pipe and near that area. Water from the damaged pipe pooled apparently on the road the motorcyclist was. So I'm guessing it flowed downhill or something, froze, created an ice patch. There were no warning signs, cones, or other measures in place. And this had happened other times before, and they allege, and that they should have known this was going to create problems. So I got to tell you, this is a very valid lawsuit where when somebody creates a condition, you have the duty to warn of that condition. Was it foreseeable that water would freeze? Was it foreseeable that water would flow to that area? All questions of fact, but I think you have a duty.
I think so too, but I'm not sure it's the fire department's duty. And again, this is kind of like conflicting allegations. Either they're calling it a water main. I'm wondering, how do we crash into a water main? It's got to be like a hydrant or something. But
right.
Did the fire department crash into it, or was it just leaking? And if it was leaking for a long period of time, I think that's more on
the county,
the water department, whoever that is, the county or whoever maintains the water system. Our duty, I would imagine, would be, and particularly if we damaged it, we've got to make the notifications. I'm assuming when it got damaged, it was not freezing, and then the notifications, whatever, don't translate into either sand or whatever it is that they use out there, salt or whatever, to make it safe, at least until you can get it fixed.
Right.
When I read it, back in the day, back in the late 70s, early 80s, the city of Providence was in a lot of trouble, and we had, obviously we're driving around with trucks with 500 gallons of water in it, and in the freezing cold, we had trucks we used to refer to. They had leaky tanks. We used to refer to them as the Zambonis. I don't know if you know what a Zamboni
yeah,
is.
Of course.
Well, some people may not. Zamboni is what they use on ice rinks to smooth the ice out in between
a hockey game
periods. Yeah, in a hockey game. So, but we referred to the trucks as Zambonis, and they really needed, on a really cold night, you really needed a sander to follow the fire truck. It's a real problem. And sometimes, leaky tank isn't really a big deal in July. But in New England, December, January, February, it's, you're looking at, this type of a problem here. So.
Right. So at least there are facts that, it's not such a horrible claim. It's unfortunate it happened. But, they'll see what actually happened. As we saw from the first lawsuit, maybe what somebody says happened isn't exactly what happened. So who knows? Okay, let's go to Tulsa, where we have another lawsuit. This is, again, very unfortunate. And there's some missing allegations in here. I couldn't find the fill in the blanks, but we have a Tulsa woman filed suit against the City of Tulsa and the Tulsa Fire Department. She alleges that a fire truck, which was being driven, and I can't tell if it was to an emergency or not, but she alleges it was carelessly, negligently, and recklessly driven, such that it caused an accident that resulted in the death of her unborn child. She was pregnant at the time. So this was in February of 24. Martin was a passenger of the vehicle. Rucker was driving it, was turning left onto a road at the same time. And all it says is a Tulsa firefighter was responding in a fire truck westbound on East 41st, quote, in the wrong lane of traffic at a high rate of speed. I'm assuming that they were driving to a call, but, you know, the whole question here is going to be one, well, I'll start with, I don't know, I didn't look, what are the state laws that protect the driver of a fire truck, if any, and what duties does that driver have, and what benefits can, what laws can they violate, so to speak? Can they go the wrong way down a one-way street? Can they exceed the speed limit? Or is there a qualifier? Must always drive with a duty of care? And we saw a lawsuit decision, right, last week where I believe a judge said, you weren't really paying attention, and, found fault in the driving of fire apparatus, how it was driven, and found the fire department liable, as I recall. In any event, this is just an unfortunate, it's an unfortunate, I hope, well, they're not arguing unfortunate, they're saying reckless. But without facts, we have no idea.
Yeah, I go back to one of my early days, and I was rather on the aggressive side of driving when I was 22, and I had one of the drivers assigned to the ladder company in my station was a senior guy, and he said, if a kid runs out in front of you and you can't stop, there's no amount of I'm sorry's that are going to change a thing. And I don't know whether this guy was, but that resonated with me. And as I get older, it resonates more and more. But when you're driving a truck, you're not thinking about what if I get in an accident, or whether it's my fault or somebody else's fault, or whatever.
You're thinking about getting the emergency,
right? And then on top of that, you're not thinking about maybe it's going to be a minor accident, because we're not really, in a high speed situation, but you can't pick your victims.
right?
Right. And if your victim has a condition that even a minor crash could cause some serious consequences.
And there aren't many minor crashes with a 15 or 30 ton truck. Ariel, which weighs 62,000 pounds, the 5 miles an hour getting hit by that versus 5 miles an hour getting hit by a car, very different world. Yeah. And we don't break the same either. So I know there's a lot of talk in the EMS world right now, and this always kind of comes in waves about responding without lights and sirens to medical emergencies. Yeah. And to a normal smells and bells call, I also wonder, is it worth it?
There's a part of that I think makes sense. In my jurisdiction here, where I think our town has grand total, we got 39 square miles. I think we have a total of 2 red lights.
Yeah.
And we don't have traffic, but I think when you think about heavy traffic, that's a different story. And to say that it could take you 20 minutes to go 8 blocks in heavy traffic, and that right. So I think there's an equation. It's not just the nature of the call, but also there's a traffic concern as well, and that how long can we tie up pieces of apparatus sitting in traffic. So.
Right. And I always say, listen, just because your lights and sirens are on doesn't mean you need to go the wrong way down traffic or speed. Just clear people out ahead of you.
I say there should be people say, anytime you turn your lights and your siren on, there's an increased risk of harm to others. Absolutely not. And if there is, you've got a training issue or a cultural right. issue in your organization. There should be no greater risk to anyone, the civilians or the firefighters on board. No greater risk of an accident with your lights on or without.
And the point, frankly, is to lower the risk, because they know you're coming. They should be getting out of the way.
Yeah.
and anyway, okay. So you and I aren't teaching a driving course, but there are so many of
But
these.
we digress.
Yeah, but we digress. So why don't you take this? This is your
Yeah.
burning question. We're not going to agree on this, so I'm so excited.
That's fine. And that's cool. And
I
I
like
come from.
not agree.
I think some of it is your background and or our backgrounds are different. But my mom was a union teacher, and I remember her in August some years gravely concerned about having to go on strike, not wanting to go on strike, but at the same time realizing that without labor that the elected officials would just take advantage of of their teachers. So and I remember that and having conversations with her. And then of course I got on Providence and joined the union and proudly joined the union and served on the executive board until I got into management. And so I try to strike a balance because obviously I spent most of my life as a manager, not so much as a union rep, union member. But here's the situation. It's a law enforcement case, and to me, it's fascinating. And I've tried to
It
reach out
is.
to a bunch of different people. A couple have gotten back to me, and I thank them. Frank Ritchie did, Ed Roy's, a couple of attorneys and firefighters out there that got back. But the question here is are certainly the public records law applies to us as public employees in ways that we don't normally think about. And Brad, if you and I are at a fire scene, and I'm the incident commander, and you've got the Charlie sector, and you and I, for whatever reason, we don't want to tie up the radio, we text each other back and forth. Those are public records. Those are public records, and
It is
some
a
first
record. I agree with you.
First Amendment auditor could come in if they knew that it happened and say, "I want all the text messages between Curt and Brad," and that's part of, and it wasn't our decision. It was the legislature who decided to enact the public records law. Okay, so work-related text messages, just like work-related reports, work-related letters, and other records are public records, and the public has a right to them. Okay, so that's number one. Employees that are in a collective bargaining environment, okay, where they have basically, if you're in the private sector, you have the National Labor Relations Act. If you're in the public sector, your state would have had to enact a law that basically says employees have the right to engage in concerted activities for their mutual aid and protection. And it's that magic language there that provides employees with protection from their employer and makes it an unfair labor practice for their employer to impede or infringe on their right to engage in concerted activities. What does that apply to? Correspondence between a member and a union rep,
Yes.
conversations at a union meeting where a firefighter stands up and says, "That damn Chief Barone, I put in for a vacation and that SOB wouldn't give me my vacation. And he's a jerk and we ought to take a vote of no confidence." All the stuff that gets said at union meetings, okay? That's protected. And as hurtful as some of the stuff may be, and as job related, work related as arguably it is, it's protected by concerted activities protection. It's what we refer to as water cooler conversation. So now we have this police department where the department had a sergeant that was in charge of some operation, and bottom line is a detective who's also the president, the local union president, communicates with him about what he's doing. So it has aspects of both work, but it also has aspects of union communication. And I think that's really sort of the crux of the issue here. But bottom line is the police department higher ups, a captain finds out about it and orders both of them to produce their text messages back and forth. And they both said, "Wait a minute, this is water cooler conversation. This is like stuff that happens in a union meeting." And the captain's saying, "No, it's not." And there's another aspect to something being a public record. If you're a public employee and you have possession of a public record and you were duly ordered to produce it, that's a criminal offense in most jurisdictions. So there's a couple where it's not, but in most jurisdictions, that's a criminal offense. Now, that assumes that you have the only copy of it. Now, if there's another copy at headquarters, that's not a big deal. But in this case, these two officers are facing potential criminal charges. They're also facing disciplinary charges. And the issue is it a public record or is it water cooler conversation? I think it's a fascinating question. I think factually we don't know because we don't really know, was it more work related or was it work related? Was it kind of in the ordinary course of the police department's business, or was it legitimate union communication that needs protection? And the courts here in Rhode Island, I think, would be a little bit more objective about this than certain states that are really kind of more pro-management. And so I don't know how that's going to play out in Florida, but at any rate, that go ahead.
Yeah, my 2 cents are not that different. I'm more on the sunshine laws, which are more the open meetings and the public records access. So on the one hand, I would argue, and I think we would agree, as a union, they're not part of a public entity. The union is separate and they won't fall, their records would not be subject to public disclosure because if it's for if they're writing them in the capacity of the union, their union records are not public records. Unions aren't public. If, however, they said, okay, and same line, yeah, there might be the NLRA or some other privacy concerning language you can't violate, can't stop your employees from talking about union or terms or conditions of employment. So if they're talking about the union, that's one thing. If they're talking about terms and conditions of their employment, now they are certainly a public record, right? But what I advocate if I was fighting this in court is that under Florida's and many other states, Florida, I think, came out first with a lot of this, and a lot of places have copied. But the interagency exception, intra-agency materials exception says that you have to release all discussions between employees, basically, within the agency, unless they're non-final policy decisions or don't lead to a final policy decision. So two low-level employees not talking to a manager about, hey, this is what I think the entity should do, that may be totally exempt, even though it's a public record, may be exempt from disclosure. But I think the biggest one is really what you raise, that this is dangerous, right?
Well, if the police department can force the disclosure of communication between a union president and a member about something that may violate the collective bargaining agreement, and that's really the thing. If it is truly about whether or not something is going to violate the collective bargaining agreement, then what's to stop them from the police chief calling in someone who was at a union meeting and say, I want to know what the president said about me. I want to know what somebody said about another ranking officer.
Yeah, I personally, in New York, I'm the guy who wrote the New York State, the book in New York, the only book in New York on the Freedom of Information Law and the Open Meetings Law. But that's about New York. Now, again, most of these laws are generally the same with the same exceptions, but I don't think it's really would be disclosable as a public record. I don't think I don't think it would fall in it, but people have to be careful. This sword cuts two ways, does it not? So then I would have the right to know.
Yeah.
Right. What everybody else, what the mayor is saying, what everyone else are saying. And, but there's a difference. The difference is two employees may not be the entity, a public official who has any right to make any final decision. So their thoughts about it don't matter.
Yeah, I'm not sure that the final decision, because if you and I go to a fire and I take a picture, that picture is a public record.
Well, but under a different section of the Freedom of Information Law, right?
It may be, but the bottom line is when you create a record, it's a public record. Now, preliminary stuff that's preliminary, like let's say you and I are working on a report. We're investigating maybe a line of duty death, and you and I are going back and forth. It's all preliminary stuff. To some extent, yeah, that I can argue is preliminary. But when the end result is the communication itself is final. It's like,
Yeah.
again,
I don't know. Not all communications are, fall within the disclosure parameters. I don't know. And again, I'm not
yeah.
quoting New York's law. I'm just saying, or Florida's law. I'm just saying generally. But even so, here, think of like a medical report
Mhm.
is right protected by a federal law.
Yeah.
It's clearly a document, but
Mhm.
it's not subject to disclosure. Why? Because another
Well,
federal law prohibits it.
well,
So
it is subject to disclosure, but you have to redact the parts that are prohibited from release by that federal law.
see that's okay, and we're going way too far down the
Yeah.
FOIL rabbit hole, right?
Yeah. Yeah.
Whether the document needs to be redacted, like for
Mhm.
example, police body cameras
Right.
are public and they have to be blacked out, but you still have to release it,
That's right.
right?
Yeah.
Versus some documents are blanket protected. I've argued successfully in court.
Mhm.
In fact, I have the only New York case that does this, but that HIPAA documents are totally protected
Really?
because
Oh, that's not the rule in most in
it's not
most states.
everywhere. And the question comes up now we're so far off with
Yeah.
HIPAA stuff is there anything you can leave that wouldn't identify the patient, right? Because anything that could identify the patient, there could be things in there, right? If you just had the medical history and you took out the date
Well,
and
you just leave
but
the date and the time of the run, and then everything else is blacked out. You can see the form, you can see all the lines on the form,
yeah,
but
but
that's it. Yeah.
there's not much. In any event, I've kept documents out from HIPAA, but here your whole point, which people need to take notice of, is this is really underhanded, right? And I don't think a court's going to allow it because my point of coming up with HIPAA is there are if a federal or state law protects the communications, you
Mhm.
can't use FOIL as a way to get around it.
Right. Yeah.
That's really my point with that. So I don't think it will succeed, but it is dirty and underhanded to try to do that.
Yeah, I think so, and I think it would, if the court sees fit to allow this, it's going to put
Oh,
a chilling effect on union to union, whether it's two colleagues together, because the right to engage in concerted activities doesn't even require a union rep. Certainly, it's strongest, I
two
think, when there's a
employees.
communication between like a union president and a member, but it it extends to just work-related communications between two just union
Yep,
members, never
sure.
mind union reps. So I don't know. It could have a chilling effect on what people are willing to say, and that's going in the opposite direction of what concerted activities is intended to, protect.
Agreed. This is why to everybody who's probably signing off by now and bored as hell.
I don't know.
But
I think there's folks that are going to stay,
it's
and see
incredibly
them.
interesting, right?
It
But this
is.
is why your attorneys need to know not one law, right? They can't do just, oh, well, I'm a personal injury lawyer. You would never figure this stuff out, right? It's
No.
the reason I
The
don't do
only ones who can
divorce and
do that are
bankruptcy.
judges. They have clairvoyance when all of a sudden they're experts in the FLSA, and then the next thing you know, they're experts at apparatus accidents, and then they're
Yep.
experts at union
Yep.
stuff, and then we wonder why we get the decisions that we get. So, no
Exactly.
offense to our friend Chip Comstock, who
It's ready for a
is
judge.
Chip is running for appellate
Yes.
court judge position. It's an elected position in Ohio, so.
And good luck to him, by the way. He should win. We
Yeah.
hope he wins.
Yeah. So we need more firefighter attorney lawyers, firefighter attorney judges. So,
Yes, yes. Well, he'll be the first. Well, I know a couple actually, but yeah.
do you? Oh, good.
Yeah,
Yeah.
yeah. Then one's the circuit court, one's the family court. But yeah,
I did. I knew one in New York. I knew one Valley Cottage.
yeah.
So,
I just appeared in front of one in Suffolk County. And by the way, could you call me right after this?
uh,
If you could. Seriously, call me after this. Hi.
all
We're
right. Well,
good.
that's gonna do it for another edition of Fire Law Roundup. If you haven't subscribed, please do. That helps our algorithm out immensely. And also, if you can click like and share, that helps us also. So, and Brad, we'll see you again next week.